5 major gun law changes are about to hit in 2026, and if you carry concealed, at least 3 of them will directly affect you. Some will save you money, others could land you in federal prison if you're not careful, and one of them is already in effect right now, which means you might already be breaking the law without even knowing it. The problem is, most of these changes happened quietly. No big press conferences, no mainstream media coverage, just legal updates buried in federal registers and state legislative sessions that flew under the radar. But here's the truth. Ignorance of the law is not a defense, and in 2026, the penalties for getting this wrong are harsher than they've ever been. So whether you're a seasoned concealed carrier or you're just getting started, you need to know what's coming. Because these aren't minor tweaks. These are major shifts at both the federal and state levels, and they're going to change how you buy, carry, store, and defend with firearms. Let's start with the federal changes first, and then we'll break down the state-level restrictions that are already causing serious problems for gun owners. Starting January 1st, 2026, the $200 NFA tax stamp fee is officially eliminated. This is a massive federal change that affects suppressors, short-barreled rifles, short-barreled shotguns, and any other weapons classified under the National Firearms Act. If you've been holding off on buying a suppressor for home defense because you didn't want to pay that extra $200 on top of the cost of the item itself, or if you've been eyeing a short-barreled rifle for vehicle carry or home defense, this is your moment. You just saved $200. And starting January 1st, we're likely to see a major spike in NFA item purchases across the country. But before you celebrate, there's a catch. This doesn't mean registration is going away. The NFA registration process is still very much in effect. The only thing that's changing is the elimination of the $200 fee. You still have to register. You still have to go through the ATF. You still have to wait months for approval. This was signed into law as part of a broader firearms reform package that passed in July 2025, and it's one of the few pieces of good news gun owners have gotten at the federal level in years. Here's the important warning. If you already submitted a Form 4 application before January 1st and you paid the $200 fee, you're locked in. The ATF is not offering refunds. No exceptions. So if you submitted your paperwork in November or December 2025, that money's gone. You're not getting it back. If you haven't started the paperwork yet, don't. Wait until January 1st to start your application and avoid paying that $200 altogether. Mark your calendar. This date matters. Some gun dealers are already promoting pre-orders that will technically go through in January. That's fine, but you need to read the fine print very carefully. Make sure your actual ATF Form 4 submission is dated on or after January 1st, or you could still get charged the fee. The date that matters isn't when you pay the dealer. It's when the ATF receives and processes your form. Now, here's what you need to do if you're thinking about buying a suppressor, short-barreled rifle, or short-barreled shotgun. First, know your state laws. Even with the federal fee gone, several states still ban these items outright. Oppressors are still completely illegal in states like California, New York, New Jersey, Illinois, Massachusetts, Rhode Island, Delaware, and Hawaii. So if you live in one of those states, this federal change doesn't help you at all. You still can't legally own these items. Second, keep in mind the registration process is still slow. Eliminating the fee doesn't speed anything up. You'll still need fingerprinting, passport-style photos, a detailed background check, and yes, ATF processing times are still sitting between 90 and 180 days for Form 4 approvals. So plan ahead. Don't expect to buy a suppressor on January 2nd and have it in your hands by Valentine's Day. It doesn't work that way. And here are the consequences if you get this wrong. This is where people get themselves in serious trouble. Owning an unregistered NFA item is still a federal felony even after the fee goes away. That means up to 10 years in federal prison and a $250,000 fine. And yes, the ATF is still actively enforcing these rules. They haven't softened. They haven't backed off. If anything, they're more aggressive than ever. So bottom line, if you want an NFA item, wait until January 1st to apply and save yourself $200. But under no circumstances should you skip registration. The ATF will not care that the fee is gone. If your item is unregistered, you're still facing prison time. This is the biggest federal-level firearms reform we've seen in years. But some of the most aggressive changes are happening at the state level, and a few of them are already in effect. Now, this next one is already in effect. It kicked in on November 1st, 2025, just a few weeks ago. And the truth is, most gun owners don't even know what happened. The United States Sentencing Commission has officially updated the federal sentencing guidelines for gun-related crimes. That means harsher penalties for straw purchases, false statements on Form 4473, and illegal firearm transfers. Let's break it down. A straw purchase happens when someone buys a gun on behalf of someone who can't legally own one. For example, your buddy has a felony conviction, so he gives you the cash and you walk into the store and buy the gun for him. That's a straw purchase, and it's a federal felony. Before this rule change, you were looking at up to 5 years in prison. But now the penalty has doubled. You're looking at up to 10 years behind bars. And this isn't just theory. The ATF is actively hunting these cases down right now. They're comparing Form 44073s to financial records, reviewing surveillance footage from gun stores, and monitoring social media activity. In 2024 alone, the ATF brought charges in over 300 straw purchase cases. That number is only going up in 2025 and 2026. Why? Because the new sentencing guidelines are now tough enough that federal prosecutors are prioritizing these cases. Another trap that's catching people is lying on Form 4473. One of the most common mistakes gun buyers make is lying, sometimes unintentionally, on question 21E of the background check form. That question asks, are you an unlawful user of marijuana or any controlled substance? Here's the kicker. Even if marijuana is legal in your state, it's still illegal federally. So if you check no on that form, but you've recently used cannabis, that's a federal felony. And now, under the updated guidelines, the penalty for that just jumped from 2 years to 5 years in federal prison. The ATF isn't taking your word for it either. They're cross-referencing Form 4473s with medical marijuana registries, DUI and drug arrest records, and yes, photos and posts on social media. If you post a picture on Instagram of yourself smoking weed and then walk into a gun store and legally buy a gun 2 weeks later, that post can be used as evidence that you lied on the federal form. They will find it. They are looking for it. And they will use it against you. So what should you do? First, never buy a gun for someone else. It doesn't matter if it's your spouse, your best friend, your brother. If they can't pass a background check, you can't legally buy a gun for them. Period. No exceptions. Second, always tell the truth on Form 4473. Every single question matters. The ATF has ways to verify your answers, and if you lie, they will find out. Third, know the rules on gifting firearms. In most states, you can give a firearm to an immediate family member without going through a licensed dealer, but only if they're legally allowed to own guns. If they're a prohibited person due to a felony, a domestic violence charge, or drug use, it's still an illegal transfer under federal law, even if no money changes hands. Bottom line, the ATF is cracking down hard. Straw purchases, lies on federal forms, and improper transfers are now high priority targets. The new sentencing rules mean longer prison terms, and prosecutors are actively looking for cases to make examples out of people. So don't take the risk. Don't try to help a friend. Don't cut corners. Don't assume you won't get caught. Federal enforcement is ramping up, and this is just the beginning. Next up, we head to Colorado, where a major change to background checks and training requirements is about to impact every new gun buyer in the state. Mark your calendar, because starting August 1st, 2026, Colorado is rolling out a major new requirement that will affect anyone buying a semi-automatic firearm in the state. Under Senate Bill 3, which was signed into law back in April 2025, you'll need to complete a state-approved safety training course and obtain a permit before you can legally take possession of any semi-automatic firearm. Now, to be clear, this law does not ban semi-automatic guns. You can still legally purchase AR-15s, semi-automatic pistols, and semi-automatic shotguns in Colorado. But here's the key. You can't take them home unless you've completed the training and received your permit. No permit, no transfer. The dealer cannot legally hand you the firearm. The training course is a minimum of 4 hours, and it must include safe handling and storage, a detailed rundown of Colorado-specific gun laws, and a live fire qualification at a range. This isn't an online course you can breeze through in an hour. You have to show up in person, you have to shoot, and you have to pass. Here's why this hits concealed carriers hard. If you already hold a valid Colorado concealed carry permit, you're in luck. You're exempt from this new training requirement. Your concealed carry permit covers it. But if you don't have a concealed carry permit and you plan to buy a semi-automatic firearm after August 1st, you'll need to complete this training course first. And it's not free. Expect to pay between $75 and $150, depending on the provider. And here's the long-term problem. The permit is only valid for 5 years. After that, you'll need to take a refresher course to renew it. That means this becomes part of the ongoing cost of gun ownership in Colorado. It's not a one-and-done deal. Also, the training has to be done through a state-approved instructor. The Colorado Bureau of Investigation is handling the certifications, and the official list of approved instructors will be available by June 1st, 2026. So if you're signing up for a course, make sure the instructor is on that list. If they're not, your training won't count, and you'll have to do it all over again. What should you do right now? If you already have a Colorado concealed carry permit, you're good. No extra steps needed. If you don't have a permit, but you plan to buy a semi-automatic firearm after August 1st, start hunting for an approved training course now. These classes are going to fill up fast, especially in July 2026, right before the deadline. And here are the legal penalties. Taking possession of a semi-automatic firearm without the required permit after August 1st is a Class 2 misdemeanor. That could mean up to 120 days in jail and a $750 fine. Gun dealers are also on the hook. If they transfer a firearm without verifying the buyer's permit, they face the same penalties. So expect dealers to get very strict with enforcement once August hits. This isn't just a rule change, it's a whole new layer of regulation that every Colorado gun owner will need to understand and follow closely. Heads up if you live in Kentucky, because starting February 1st, 2026, the state is rolling out one of the broadest red flag laws we've seen in the country. It's officially called an Extreme Risk Protection Order, or ERPO for short. This law was passed by the Kentucky legislature in March 2025 and signed into law the following month. That makes Kentucky the 22nd state to adopt a red flag law, but this version goes further than most. Here's how it works. If someone believes you pose a danger to yourself or others, they can petition the court to have your firearms taken away, even if you haven't committed a crime. And here's the real shocker. This can all happen before you ever get a chance to defend yourself in court. If the court grants the emergency ERPO, you'll be legally required to surrender all firearms within 24 hours, you'll immediately lose your concealed carry rights, and you might not even know what's happening until law enforcement shows up at your door with the order. Who can file against you? The list is broad, and you need to be aware of it. In Kentucky, the following people can request an ERPO against you: current or former spouses, anyone you've lived with in the past year, blood relatives or in-laws, anyone you've dated within the past 12 months, and any law enforcement officer. The standard of proof is just reasonable cause to believe. That's a very low bar. It doesn't take hard evidence or a criminal conviction, just someone's stated concern. Why does this matter for concealed carriers? If someone files an ERPO against you, even if it's exaggerated or completely false, your concealed carry permit is suspended instantly. No warning. No court date at first, no chance to fight back initially. You have 24 hours to turn over your guns, and you won't get them back until the court says so. You do get your day in court eventually. Within 14 days, there's a hearing where you can present evidence and defend yourself. But during those 2 weeks, you can't possess firearms. Your carry rights are gone, and your name could be flagged in law enforcement databases statewide. If the court decides to make the order permanent, it lasts up to 1 full year. And after that, it can be renewed if the petitioner comes back with a new request. What should you do right now if you live in Kentucky? First, know who can file against you. If you're in the middle of a divorce, a custody battle, or a family conflict, document everything. Keep text messages, emails, witnesses, anything that could prove your side if someone files a false claim. Second, if an ERPO is filed against you, lawyer up immediately. This is not a small claims case. This is your Second Amendment rights on the line. You need an attorney who specializes in firearms law or civil rights, and you need them fast. That 14-day hearing comes quick, and you don't get a second shot if you're unprepared. Third, understand that violating an ERPO is serious. If you're caught with a firearm while under an active ERPO, that's a Class D felony in Kentucky. You're looking at 1 to 5 years in prison, and even after the order expires, you can't just pick your guns back up. You'll have to petition the court to return them, and that process can drag out for weeks or months. This isn't just a temporary inconvenience. It can have long-term consequences for your rights, your record, and your ability to carry. And Kentucky isn't alone. More states are watching how this plays out, and some are already working on copycat bills. But while states are tightening gun restrictions, there's one federal law on the table right now that could flip the entire system. This one could change everything for concealed carriers across the country. In January 2025, lawmakers reintroduced the Constitutional Concealed Carry Reciprocity Act, better known as H.R. 38. And if it passes in 2026, which many believe it could, it would be the biggest shift in concealed carry law in American history. Here's what it does. H.R. 38 would require all 50 states to honor concealed carry permits issued by any other state. Just like your driver's license is valid nationwide, your concealed carry permit would work everywhere, no matter where you're traveling. Right now, it's a legal minefield. Texas honors permits from 42 states. Florida accepts 38, but California, 0. New York, almost none. New Jersey, none at all. So if you have a valid permit in Texas and you drive through New Jersey with your firearm, you're committing a felony under current law. If H.R. 38 becomes law, your Texas permit would be valid in California. Your Florida permit would work in New York. Your Arizona permit would be honored in New Jersey. States wouldn't be allowed to add extra restrictions. They'd have to recognize your carry permit, period. Where does the bill stand right now? H.R. 38 passed the House once before, back in 2017, but it stalled in the Senate and never became law. Now it's back with 213 co-sponsors. That's nearly half the House already on board. It's currently sitting in the House Judiciary Committee. If it makes it out of committee and clears the House again, it heads to the Senate, where its fate is still uncertain. Why does it matter to you? If you carry concealed and you travel across state lines, this would be an absolute game changer. Right now, you need to check reciprocity maps every time you travel, juggle multiple non-resident permits if you want broad coverage, and risk breaking the law without even realizing it, because the rules change constantly. If H.R. 38 becomes law, all you'd need is your home state permit, and you'd be legal in all 50 states. But, and this is critically important, it's not law yet. It's still in committee. It hasn't passed either chamber. Even if it does pass, some states will almost certainly challenge it in court, which could delay or even block enforcement for years. So don't assume it's active. Until you see it signed into law by the president and upheld in federal court, you absolutely must follow the current rules. Here's what you should do now. Track the progress of H.R. 38 closely. If you travel often, consider getting non-resident permits from states with wide reciprocity agreements. Florida, Utah, and Arizona are your best bets. And always double-check current reciprocity maps before crossing state lines with a firearm. Don't rely on outdated information. Laws change. Agreements expire. What was legal last year might not be legal today. Let's recap everything you need to know. January 1st, 2026, the $200 NFA tax stamp is eliminated. February 1st, 2026, Kentucky's new red flag law takes effect. August 1st, 2026, Colorado's new training and permit rule kicks in. And remember, the new federal sentencing guidelines for straw purchases and lying on Form 4473 already went live on November 1st, 2025. So here's your action plan. Check if your state is impacted by these changes. If you're planning to buy a suppressor or short-barreled firearm, wait until January 1st to save $200. Never lie on Form 4473, even if you think it's a small detail. Don't make a straw purchase for anyone, ever. The penalties are now harsher than they've ever been. Track H.R. 38's progress if you travel with your firearm. And if you carry often across state lines, get those non-resident permits now. Gun laws in America are changing fast and sometimes very quietly. Staying legal means staying informed. That's exactly why you should subscribe to this channel right now. Hit that bell icon so you never miss an update, because we're tracking every major gun law change as it happens, state by state and federal level. Next week, I'm breaking down the ATF's latest pistol brace rule and why so many gun owners are absolutely furious about it. Until then, stay sharp, stay legal, and stay free. We'll see you in the next video.